Good afternoon, everyone. Welcome to our session on how to convert a loss into a win. This really is inspired by a question I often get asked by employer clients when asking for them. They will often ask, am I going to win this claim? And my answer to them is a very lawyer type answer, which is, well, it depends what you mean by win. Because there are plenty of claims where employer clients have perhaps lost on the liability hearing, so there might be a finding of unfair dismissal, but if the remedy is manageable and often less than an amount that they would have been willing or might have offered to settle for, then as a lawyer, I would define that as a win. So what we wanted to do today was to spend some time exploring the issue of remedies in the Employment Tribunal, which is sometimes neglected. Sometimes people concentrate on liability, and we want to look at the issue of remedies and what the ultimate outcome of a hearing might be. As Tom mentioned, if you've got any questions as we go along, if you use the Q&A function, then if we've got time at the end, we'll pick up those questions. Just before I start, I'm from Nottingham, and there are a few famous people from Nottingham. Robin Hood, although there is some historical debate about that, but that's for another webinar. Brian Clough, probably now you'd say Vicky McClure, and a chap called Dennis Polkey, a van driver from Nottingham, who 36 years yesterday won an argument in the House of Lords, and his name thereafter is probably the most famous name of a claimant in employment tribunal litigation. I can guarantee that at every employment tribunal in the country today, there will be a reference to Dennis Polkey, and Amanda's going to explain where that comes from. Before Amanda deals with contributions and why Mr. Polkey is so famous, Nicola's going to take us through issues around reinstatement and re-engagement. Thanks, Nicola.
Thanks very much, Matt. Afternoon, everybody. So I'm going to take you through, as Matt just said, looking at reinstatement and re-engagement. I think when people think about employment tribunals and potential remedies, they often fix initially on money. How much is this going to cost us? How much is the claimant going to get if we lose? But before we talk about money, it is important to consider two often neglected remedies that are also available in the Employment Tribunal. And these apply in cases of unfair dismissal and are reinstatement and re-engagement. They are rare. They end up applying in less than 1% of cases. But even though they're rare, it's important to be aware of them if you're going through a tribunal process. So let's take a look at each of those in turn. Firstly, then, reinstatement. This is where the employee is treated as if they had never been dismissed. They're slotted back into the same job with their continuity of employment preserved, and they're given back pay so that if the claim is heard, say 18 months after dismissal, they will get 18 months back pay, less any other earnings in that period. Pension rights are preserved and they'll get back paid contributions, and they'll also obtain the benefit of any pay rises that took effect in the period in which they were out. Re-engagement is slightly different, and that's where it's engagement in employment that is comparable to or to the original job or in some other suitable employment. So it's not reinstatement back to exactly the same job, a different job with the same employer. We see this sort of remedy in cases of large employers, for example, police, National Health Service, for example, and it's where you're unfairly dismissed from one team, but you might want, instead of compensation, to be re-engaged into a different team who operate, for example, out of a different office or hospital. We see these cases more in the public sector or perhaps private sector employers with defined benefit pension schemes. Because if you had, say, a public sector worker age 30 on a salary of, say, £30,000 who's unfairly dismissed, their maximum compensation award for unfair dismissal would be £30,000. For that particular individual, it may be more valuable for them to go back to their original job or one like it, where they could be reinstated or re-engaged and get the benefit back of their final salary or defined benefit pension scheme, which they'd be unlikely to replicate with another employer. It's also worth noting, as it says on the slide there, that these remedies can apply to successors. So an individual unfairly dismissed due to a 2P transfer might be ordered to be re-engaged by the transferee, for example. An element of law that's often forgotten by employers, lawyers, and even judges is that whenever there's the finding of unfair dismissal, the rules say that the judge has to explain to the claimant that these remedies are available and ask the claimant if it's something that they are interested in. And for many claimants, it's the first time that they've been asked the question, and sometimes they say yes, they are interested, which can cause a bit of panic for the employer there at the tribunal, who will then be asked their views on it. So employers need to go into hearings being prepared for that scenario. Sometimes it's been covered off in a preliminary hearing or case management discussion, but in cases of straightforward unfair dismissal where there haven't been earlier hearings, this might be the first time it's really cropped up. So apply your minds in advance to think about what you would say on this. The judge has some specific factors that they're directed to consider when looking at this question. Does the claimant want to be reinstated or re-engaged? A tribunal is not going to order it against a claimant's will. Whether it's practicable. Case law on this, and we've referred to the authority there on the slide, it states that what is practicable goes beyond what is just possible and means, is this capable of being carried into effect with success? So they will look at the surrounding circumstances, and a tribunal might think, okay, well, during the course of this hearing, the claimant called his manager a dirty, scheming liar. In that scenario, the tribunal is likely to conclude that reinstatement to their previous job is unlikely to be successful because of the resentment, bad feeling caused during the tribunal process. But reinstatement to the same job with that manager might not work, but re-engagement to a different team or workplace might still be practicable in those circumstances. They'll also look at things like whether the claimant contributed to their own dismissal. If they were dismissed for theft and found to be unfairly dismissed on purely procedural grounds, a tribunal is unlikely to reinstate them. And it's for this sort of reason that judges often veer away from granting reinstatement or re-engagement. The judge doesn't want to be responsible for causing more problems and a difficult working relationship that may well end up before the tribunal again in due course if it's just never going to work from the outset. Another common argument that gets looked at and that often gets raised is, well, what if the employer's already recruited a replacement? Common issue, and the general position is that that isn't an automatic get out of jail free card that avoids the need for re-engagement or reinstatement. Otherwise, it would just be all too easy for an employer to say, oh no, we filled that gap, we can't possibly have someone back. So the tribunal will look at a number of questions here. Did the respondent have good reasons to get a replacement? Was it not practicable to get the work done without a permanent replacement? Had a reasonable period passed without the claimant asking to be reinstated or re-engaged, by which point it was no longer reasonable for the employer to get the work done other than by the recruitment of a permanent replacement. That's all I really wanted to say on these things, and I'll hand over to Amanda to talk about the financial remedies.
Thank you, Nicola, and good afternoon again, everybody. So as Nicola said, I'm now going to be looking at financial compensation in relation to unfair dismissal claims. And on the slide in front of you there, you'll see the definition as to what's included in the compensatory award under the Employment Rights Act. So it's such amount as the tribunal considers just and equitable in all of the circumstances, having regard to the loss that's been sustained by the claimant, that's in consequence of the dismissal, and insofar as that loss is attributable to action taken by the employer. And I think the most important part really to take from the definition there is that it's such amount as the tribunal considers just and equitable. So there's no sort of standard formula that they have to follow as such. And next slide, please. So unfair dismissal awards are broken down into two different headings, the basic awards and the compensatory award. Now, the basic award is calculated in exactly the same way as redundancy pay. So this does follow a strict formula. As you may know, it's 1 week's pay for each year of service where the employee is under or up to 41 years old, and a week and a half's pay once they're over 41. And that's subject to a maximum of 20 years that are taken into account. And a week's pay is also capped. So it's not necessarily their 4 weeks' pay, but it's a maximum of currently £643 per week. So the basic award there is very straightforward to calculate. They will also be awarded a compensatory award if they're successful, which, as I said, from the definition there is less straightforward and does come down to what the tribunal believes is just and equitable in the circumstances. So the first thing the tribunal will look at is the employee's past losses. This part is fairly easy to calculate. It will be the loss from the period they were dismissed until the point that you're at the tribunal hearing, and that will be based on their net losses. Next, they'll be looking at whether there's any future loss to be taken into account. So this will be where you've got to the tribunal hearing and the employee still hasn't found a new role, or perhaps they found a new role but on a lower salary they were on before. The tribunal's then got to assess for what period of time the employee should be allowed to have compensation for the losses until they're expected to have found a new job or equivalent job in terms of salary. So again, here there's no fixed time period and it will depend upon the circumstances. An issue such as mitigation that the employee has or hasn't done. I'll be coming to that a bit later. The next calculation the tribunal will make is to look and see if there are any deductions that they can make from the award, which here is very important for the employer. And the order of the deductions is as set out on the bullet points in front of you there. So it is, again, a strict order. They will always do it in this order. So first of all, they'll look at were there any sums already paid by the employer to the employee. So this would be, say, ex gratia payments that you might have made when they left. You then get credit for that and it's taken off of the award. Next, they'll look at whether there are any sums that have been earned by the employee in the meantime. So it may be that they perhaps took on some temporary work but haven't found permanent work yet, so that their losses are continuing, and then the employee will get credit for the amounts they've earned. Next, we have a few different principles here. As Matt mentioned earlier, Polkey arguments, which I'm going to go into in a bit more detail in a moment, deductions in relation to the ACAS code, and contributory fault, which again, we're going to go over those in some detail. And the final deduction would be any enhanced redundancy pay that you made to the employee. Again, you'll get credit for that. The next step that the tribunal will take will be any grossing up that's required. And this relates to the taxation on the compensation award. The first £30,000 of compensation, provided it's in addition to any notice pay required, is tax-free generally. However, any amount over the £30,000, the employee will have to pay tax on. Therefore, as awards are calculated based on net losses, if they do have to pay some tax, then the award is increased as the employer has to pay a bit more so that the employee ends up with the same net losses. And then the final bit that the tribunal will look at is the application of the statutory cap. And this applies whenever it's an ordinary unfair dismissal claim. And the maximum award for a compensatory award is the lower of a year's pay or the statutory amount, which is currently £105,707. So as I said, as that's the final part there, and that's taken into account after any deductions are considered in grossing up. Therefore, from an employer's perspective, that's the maximum they'll be awarded under the compensatory award heading. So just looking at some of the potential deductions from compensation in a bit more detail. The first principle is in relation to Polkey. So as Matt said, very famous case. It's from 1987, Polkey and AE Dayton Services Ltd. It related to a van driver. Mr. Polkey was one of 4 van drivers, and I think the company decided they didn't need van drivers so much anymore. They wanted van salespeople, and so they made some of them redundant. Mr. Polkey was one of those. 3 out of 4 of them were made redundant, and they just called him into a meeting, said, "I'm sorry, but we don't need you anymore," and gave him a letter. So there was no consultation whatsoever. And understandably, Mr. Polkey wasn't very happy with that. He therefore brought a claim for unfair dismissal. Now, in the Employment Tribunal, the tribunal found on evidence from the respondent, even if they'd carried out a consultation, that redundancy still would have happened. And so there was a chance that Mr. Polkey would have still been made redundant. The tribunal therefore found that he was not unfairly dismissed at first instance. However, understandably, again, Mr. Polkey wasn't happy with that and appealed the decision. And this case did go all the way to the House of Lords. It was the House of Lords that decided that the tribunal were wrong in their decision. And whether consultation would have made a difference to the outcome as to whether he'd be made redundant or not isn't relevant to the fairness of the dismissal. So if a fair procedure hasn't been followed, it will be an unfair dismissal. However, what would have happened is relevant to the remedies. So it's relevant to the compensation that the employee can be awarded. And the question they have to ask is, would the outcome have been different or the same had a fair procedure actually been followed? So as I said, even if you can make a Polkey argument, it doesn't make the dismissal fair. Unfortunately, it would still be an unfair dismissal. However, the compensation can be reduced by the tribunal, and it can be reduced by any amount up to even 100%. So you can get a situation which is as close as you can get to a win for an employer in the tribunal, really, if the unfair dismissal has been founded. However, the employee may actually receive with 0 financial compensation. And generally, the way that the deduction is carried out is as a percentage reduction based on the chance that the person would have still been made redundant. So to use Polkey as an example, where 3 out of 4 people were going to be made redundant, the tribunal could decide that there's, say, a 75% reduction in compensation to take that into consideration. Another way that Polkey can apply would be if you as the employer can show evidence that actually the employee would have been dismissed, say for another reason, potentially a short period of time afterwards, then the compensation that the employee can receive could be reduced just to the period of time that it would have taken until they were then fairly dismissed. So in terms of strategy here, it's really important as an employer to plead a Polkey argument in your response to the claim, so that the Employment Tribunal can see, well, what are you saying would have happened if a fair procedure had been carried out? So it is important that you put that evidence before the tribunal. And just one further point, that Polkey reductions only relate to the compensatory award. So unfortunately, the employee would still be entitled to a basic award if unfair dismissal has been found. And the next slide, please. So the next principle where you can get a reduction in the tribunal's award to the employee is contributory fault. So this is where an employee is dismissed and it is found by a tribunal to be an unfair dismissal, but say they find that there hasn't been a sufficient reason to dismiss. However, they might find that the claimant's conduct has in some way contributed to their dismissal. And similarly to Polkey, a reduction can be made here again up to 100% of the award, so potentially leaving the employee with no financial award. Unlike Polkey, reductions in relation to contributory fault can actually reduce the basic award as well as the compensatory award. So for the basic award, it's 2 different tests, and for basic, you just have to show that the claimant's conduct before dismissal is such that it would be just and equitable to reduce their compensation. So for the basic award, it didn't need to have contributed to their dismissal, and the employer didn't even actually have to know about that conduct at the time. If they found out about it later, you can still bring that into your defence and your claim. For the compensatory award, you'd have to show that the dismissal was to some extent caused or contributed to by the action of the employee. And then compensation can be reduced by such proportion as the tribunal decides is just and equitable in the circumstances. So in the case of Steen and ASP packaging, this claim held the questions that the tribunal have to consider to decide whether a reduction should be made for contributory fault or conduct. So first of all, of course, what was the conduct? What did they do wrong? Was that conduct blameworthy, irrespective of the employer's view, so on an objective basis? Did that blameworthy conduct cause or contribute to the dismissal? And then finally, to what extent should the award be reduced because of that? So just looking at a couple of cases there, in the case of Jagex and McCambridge, here it held that the conduct doesn't need to be so serious as to amount to gross misconduct for a contributory fault reduction to be made. So the facts were that Mr. McCambridge was summarily dismissed after he found some documents on a communal printer, and the documents had the salary details of some senior executives of the company. And Mr. McCambridge unwisely then told some of his colleagues what he'd seen. The company found out he was, as I say, summarily dismissed, and he then brought a claim for unfair dismissal, and he was successful in that claim. Now, the tribunal was asked by the respondent to make a reduction in the award for his contributory fault, in that he shouldn't, of course, have told his colleagues what he'd seen. However, the tribunal refused to make any reduction as they found that it did not amount to gross misconduct. This was appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal held that it was an error in decision at the tribunal level, and that the conduct only needs to be blameworthy or culpable behaviour. So it doesn't need to be so serious that you could have dismissed them automatically. The other case there is Nixon and Ross Coates solicitors. And this case showed that the conduct must actually contribute to the person's dismissal. So it's quite a timely example, given the time of year, as you'll see. The facts were that the employee was seen kissing a colleague at the Christmas party, and then was also seen going to a hotel room with the same gentleman. She became pregnant, and when she told her employer that she was pregnant, the HR manager started spreading gossip about who the father might be. The claimant therefore raised a grievance about the HR manager, and this grievance wasn't properly dealt with by the company. Because of this, the employee resigned and claimed constructive unfair dismissal, and she was successful in her claim. However, the Employment Tribunal decided to reduce her compensation by 90%, so a really big amount, because, and I quote, she was the author of her own misfortune by acting so publicly, so foolishly, and so irresponsibly at the Christmas party. Here, Ms. Nixon appealed the decision to the Employment Appeal Tribunal, and they held that the reduction was wrong. The Employment Tribunal had erred in failing to consider whether the conduct that was blameworthy had actually contributed to her dismissal. And in this case, they held that it hadn't done. The termination of her employment related to the grievance, which wasn't dealt with properly, and not what had previously happened at the Christmas party, and therefore the compensation should not have been reduced. So with regards to contributory fault, the Employment Tribunal does have a mandatory duty to consider this if there's any evidence that they see that shows that there was some sort of contributory conduct by the claimant. However, we would always advise that you should plead this in your response to the claim, just to ensure that it is brought to the attention of the tribunal, and of course that you put forward any evidence as to what it is that you say the blameworthy conduct was. And with all of these types of potential reductions, it can also be helpful in your settlement discussions as well. If you feel that you have a good argument to make, you may be able to reduce what the expectations are of the claimant, given that their compensation could be quite substantially reduced. Now the next slide. Thank you. And the next principle is the claimant's failure to mitigate their losses. Now, mitigating losses essentially means that the employee is under a duty to try and find another job, or to earn money in another way, or to claim benefits if that's relevant to them. And although, of course, it's for the employee to try and find a new job, what I think is often misunderstood is in relation to the burden of proof in relation to mitigation. And it's actually the burden is on the respondent, the employer, to show that the claimant acted unreasonably in failing to mitigate their loss, so in failing to make enough effort to try and find another role. So the Employment Tribunal will, of course, need evidence to make any decision like this, which the respondent does need to put forward. And in terms of arguments that you can make, you could be saying that the claimant didn't make sufficient efforts to find a new role. Perhaps they confined their search to too narrow a type of role within the industry or within a location, and potentially that they've unreasonably turned down a job offer. And this could be a job offer from another organisation or even from your own organisation. Perhaps in a fire and rehire situation where you wanted to update the terms and conditions of, let's say, a group of employees or everybody. You would, of course, go through a consultation process. Hopefully everybody agrees to those changes, but you may find that some don't agree, and in which case you may end their employment and offer them employment immediately after on the new terms. Where you have an employee that turns that down, you may be able to make an argument in a future unfair dismissal claim that they failed to mitigate their losses by not accepting what was a reasonable offer for them. So of course, here we're talking about mitigation when an employee has been found that they have been unfairly dismissed. So the tribunal won't apply too demanding a standard on the claimant to show that they've mitigated their losses. And it's not enough to show that the claimant didn't do everything that they could have done to find another job. As the respondent, you need to show that the claimant had acted unreasonably in not taking certain steps. So the questions that the tribunal will ask itself are, what steps was it unreasonable for the claimant not to have taken? If they'd taken them, would those steps have produced an alternative income? And if so, when would that have been earned? So as I said earlier, it's important here to bring evidence to the tribunal in relation to mitigation. And it's something to try and do at a really early stage, such as carrying out online job searches so that you can show what jobs were on offer and what types of salaries there were. It's also important that it's set out in the witness statement as well, if you do feel that an employee or ex-employee hasn't done enough to try and find another role. And I think I'll be handing over to Matt.
Thanks, Amanda. So the first thing I wanted to look at was the ACAS Code of Practice. Some of you who've been around employment law and HR for a while may remember that more than a decade ago now, the government introduced the statutory dismissal, disciplinary and grievance procedures. And these were great news for employment lawyers because lots of money was generated giving employers advice on the statutory dismissal procedures, carrying out seminars, guiding them. And the principle of this was the employer had to follow a certain basic procedure, otherwise a dismissal would be unfair. They didn't last very long, the statutory procedures, and when they were repealed, in order to assist employees, the government said, well, now things are going to be governed by a code of practice. And ACAS set out this code of practice, and we expect employers and employees to follow the code of practice, which broadly mirrored what the statutory procedures said. So in relation to a disciplinary process, it was giving people warnings, having a hearing, giving a right to appeal, etc. But in order for that code of practice to have some teeth, then there needed to be some form of incentive to follow the code of practice for both employers and employees. So the incentive to follow the codes of practice is that if an employer does not follow the ACAS code and there is a finding of unfair dismissal against the employer, then compensation payable to the employee can be uplifted by up to 25%. But similarly, if an employee unreasonably fails to follow either the statutory disciplinary or grievance procedures, their compensation can be reduced by up to 25%. Commonly we see, in fact, I very rarely see a schedule of loss from employees seeking compensation from unfair dismissal that doesn't also seek an uplift for a failure to follow the ACAS code, and it normally seeks a 25% uplift. However, if an employer is confident that it has followed the basic ACAS code, which many of employers do, then as part of any settlement discussions, as Amanda mentioned, or ultimately, if the tribunal hearing does go to a remedies hearing, it is open to the employer to say that the employee unreasonably failed to follow the process and that therefore any compensation should be reduced. Probably the most common example of that is the employee who fails to appeal against a dismissal. The fact that they've failed to appeal against the dismissal is unlikely to impact on whether or not there's a finding of unfair dismissal. They will still be found to be unfairly dismissed if it was an unfair process, whether or not the employee appealed. However, we mentioned a case there where there was a 20% reduction in compensation for an employee's unreasonable failure to appeal. In that case, the only reason why the tribunal said they didn't order a 25% reduction was they said the employee at least had a reason for not appealing, albeit not a good one, and his reason was that he was so upset with the decision and thought an appeal would make a difference. And the tribunal said, well, whether or not you thought it would made a difference and whether or not you were disgusted at the decision, you should have appealed. So that's something to bear in mind, as we say, at settlement discussion stage, but also at ultimate hearing stage. It is possible to seek to reduce the award for a failure to follow the code of practice. Similarly, in cases that don't involve dismissal, but cases that might involve grievances, there might be discrimination cases where an employee fails to raise a grievance or fails to attend grievance hearings or fails to appeal against a grievance decision. There are cases in which employers have said, well, in those circumstances, you should reduce the compensation to the employee because had there been a grievance appeal, the outcome might have been different. We might have been able to resolve matters. So that's the ACAS code of practice. The next slide on specifically reducing compensation is around the general concept that Amanda mentioned, the general rule to tribunals in the legislation, and one of the only real rules to them is that compensation should be whatever is just and equitable in all the circumstances. So they have a fairly wide discretion. How they act upon that discretion is to a certain extent dictated by case law that has emerged over the years, so cases like the Polkey case. But generally speaking, there remains this principle that compensation should be just and equitable in all the circumstances. And this case we highlight on this slide is an example of a tribunal or the Employment Appeal Tribunal recognising that there could be circumstances in which compensation might be reduced on this basis. So what you had here was an employee who was unfairly dismissed for misconduct, and in between the unfair dismissal hearing and the scheduled remedies hearing to determine how much he should be awarded, and it's common for there to be a gap between those two hearings in the tribunal, the school found out that he was due to appear in court on some, as you'll see there, fairly serious charges. He was a teacher, and these would have impacted upon his teaching. So they said the tribunal, well, look, can we postpone the remedies hearing to see whether or not he's convicted of these offences? Because if he is convicted of these offences, we think that would impact on the remedy payable to him for the reasons which I'll mention at the end. The tribunal refused that application and awarded compensation. His employer appealed, and as it turns out, as they had predicted, in actual fact, after he'd been awarded £66,000, he was sentenced to 6 weeks imprisonment and banned from teaching for life. So the basis of the appeal was, well, in the circumstances where we, albeit unfairly, dismissed a teacher, surely it isn't right that he should get £66,000 worth of compensation, which included losses going beyond the date on which he was imprisoned and the fact that he'd been banned from teaching for life. Because had we not unfairly dismissed him, clearly he wouldn't have been able to carry on working for us because he would have been banned from teaching. And the EAT agreed with that point and said, okay, we will send this back to a fresh tribunal. So not the tribunal who determined that he was unfairly dismissed or determined that he was entitled to £66,000. will send it back to a fresh employment tribunal to determine what would be a just and equitable compensation award in those circumstances. Now, obviously, that's a particularly serious criminal charge, but there are other cases where there are circumstances where employers can say, well, even though this individual was unfairly dismissed, there is good reason why they shouldn't be unjustly enriched by this award. So it's to mention to you all as a possible argument. Next slide, please. Okay. We've talked generally, Amanda talked about financial losses, and the immediate perception around them is it tends to relate to things like loss of salary. Sometimes we think about loss of benefits. Loss of benefits employees are perfectly entitled to claim for as well. And an important benefit is pension benefits. And for some employees, less so these days, but certainly 10 or 20 years ago, a really valuable part of their remuneration package was their pension. And for that reason, it's worth touching on how we deal with and how the tribunals deal with pension loss. I mentioned there that it's both complex and potentially expensive. In the majority of cases where individuals are in auto-enrolment schemes or stakeholder schemes or private group personal pension schemes, where all the employer is doing is contributing a fixed amount to their pension scheme, whether that be 5%, 8%, whatever it may be, then the tribunal adopt what they call the simple approach, which is they say, well, in the same way as loss of salary, if your salary was £50,000 and you're entitled to 5% pension contributions, then for a year's worth of losses, we'll call it £50,000 net and 5% employer pension contributions. That's what you've lost. And they deal with it very simply. An employee might argue, particularly if, for example, their case is now heard 3 years after the dismissal, they might say, well, yeah, but had I had my pension contributions 3 years ago, they would have grown and therefore I should be entitled to more money. But employers don't tend to take that approach. They just say, well, we'll fix the point in time, because as those of you who are in pension schemes know, your 5% may grow and it may not grow. So that's how the tribunal approach it. For employees who are in defined benefit schemes, so these are typically public sector schemes, but some private sector schemes that large employers still have, where the ultimate pension the employee receives isn't determined by how much is in their pension pot, in the same way as a defined contribution scheme. It is determined by a promise to the employer or from the pension scheme that we will pay you a certain pension calculated normally with reference to either final salary or their average earnings. So the contributions that are paid throughout your employment vary in order for us to hit that endpoint, such that if you were with us for 30 years, we promise to pay you 30/60ths of your final salary, for example. And in those cases, the majority of those cases, the tribunal recognised that that calculation is a complicated one. I'll explain why it's complicated in a minute. The exceptions to that are, if an employee's been in, let's say, a public sector employment, if there's a very short period of service, so the employee's only been there a couple of years or less than a couple of years and they're claiming discrimination, for example, or that their losses are going to hit £105,000 or the annual salary cap anyway, where the tribunal says, well, it's not worth arguing about whether there's £500,000 worth of pension losses here, because the most you're going to get is £30,000. Or where there's what's called a large withdrawal factor, i.e. the circumstances are such that the employee wouldn't have remained in that defined benefit pension scheme for long, in which case they will again adopt a simple approach and say, well, let's look at what contributions your employer was paying to the scheme and we'll just operate on that basis. But if the employee says, I would have been there for a long time after dismissal, and different to finding alternative employment and an alternative salary. So yes, I was on £30,000. I ought to be able to find another job paying me £30,000. I will not find another job paying me £30,000 plus a defined benefit contribution, a defined benefit pension scheme, because there aren't many of those around anymore. And therefore my pension loss will last longer than my salary loss. And those are the cases where it applies. And you can get up talking about big figures. Let's take an employee, the employee I mentioned before. Let's say they were on a 1/60th pension scheme. So for every year they work for the employer, their final pension is worth 1/60th per year of service. If they're dismissed after 10 years service, a pension of 10/60ths of final salary. Let's assume their final salary, to make the calculation easy, £48,000. 10/60th, £48,000 is a sixth, so that's £8,000 will be their pension. If they said, well, I would have been there for another 20 years until I retire, and I'm not going to get into another defined benefit scheme during that period, what would my pension have been at the end of that 20 years? Well, it would have been £24,000, because it would have been half of my salary. So I'm missing out when I get to retirement age on £16,000 worth of pension. What does that cost in the open market now? Various different factors to take into account, but you're talking potentially £300,000 in terms of what it would cost you to buy a pension worth £16,000 per year for that employee. The complicating factors are, will that employee have been with that employer for 20 years? Various issues about how that pension would increase, index linked, etc., life expectancy of individuals. So it does get complicated, and the tribunal have two ways of looking at that. They have what's called the Ogden table approach, where they apply the sort of actuarial tables that they use in personal injury cases, or in some cases where there are significant amounts of pension loss, so typically discrimination cases where we're talking about career-ending loss, the parties might engage expert actuarial experts to calculate what that pension loss is worth. That is an expensive approach, but sometimes it's justified in terms of the amount being debated. It's only in the last few years, it's only in the last 5 years, I probably think the last 4 or 5 years, that the tribunal have tried to identify at an early stage in proceedings whether or not this is a complicated pension loss case. They will now try and do that at an early case management discussion, because if it is a complicated pension loss case, they will know they need to factor that into the timetable and probably say, we'll have a hearing on this case, we'll determine whether or not the individual has been unfairly dismissed or discriminated against, and then we'll deal with pension loss and the complications arising from it. Because we know it's complicated, but we're not going to deal with all of that at the moment because we've not decided whether or not the individual's unfairly dismissed. So we're not going to waste the costs in that area. So again, if any of you are dealing with tribunal claims for yourselves and operating in the public sector, or with a scheme that has a defined benefit scheme, it is important to identify this as a potential issue at an early stage. Next slide, please, Tom. Okay, saving the best till last, tax. And I want to talk about taxation and settlement, and the words are deliberately put in that order. The tribunal issue a number of guidance documents to their process. They try and be helpful to people, and they set out to practitioners and to claimants, this is how we will deal with cases. And their guidance on tax treatment of awards is as follows. I'll read this out to you. The rules on when tax is payable on awards made by tribunals are too complex for inclusion here. So they accept it is too complicated for them to deal with and for them to give simple guidance in relation to. The general principle is what Amanda has explained, is that tax can be payable on some elements of tribunal awards, whatever the type of claim. And if tax is payable, then in order for the employee to receive appropriate compensation, their award may need to be grossed up to reflect that tax that is payable. That's the general principle. The reason why I put taxation and settlement in that order is that I would always recommend that employers who are seeking to settle tribunal claims think about tax first before making a settlement offer. Because there is nothing worse than employer and employee negotiating a settlement deal when they are talking at cross purposes. And when the employer thinks, I'm going to be paying you £60,000, but some of that might be taxed, the employee hears, I'm going to get £60,000. Yeah, that sounds a good deal to me. Then shake hands on that deal. Lawyers draft the deal. You're getting £60,000, of which £30,000 is tax-free, the rest is taxable. And the employee thinks, hang on a minute, that's not what we agreed to. I was going to get £60,000. And it's a particularly common issue, I find, at the Employment Tribunal. For those of you involved in settlement discussions during the course of employment, there is people entering into those discussions, whether from HR or the business generally, tend to understand the concepts. Notice pay should be taxed, holiday pay should be taxed, anything else tax-free up to £30,000, but you'll be taxed after that. There is generally an understanding of that. When you're at the Employment Tribunal, perhaps at the morning of the tribunal negotiating settlement, sometimes that is forgotten and people have a different perception of how Employment Tribunal awards should be taxed. They're not thinking this is notice pay or this is holiday pay or this is £30,000. They're just thinking this is a global figure to settle your claim and for you to go away. So it is important those tax issues are covered. Because they are complex, I'm only going to give sort of headline views here on the general broad principles. Amanda's mentioned that basic and compensatory awards for unfair dismissal generally tax-free up to £30,000, but the remainder is taxable and therefore needs to be grossed up. Compensation for notice pay is likely to be taxed as post-employment notice pay. So if there's a wrongful dismissal claim and the individual is entitled to 3 months' notice, the award will be for 3 months' pay, but subject to tax. Injury to feelings is where it gets a bit more complex, in that it depends what the event was that caused the injury to feelings. So if it's a claim relating to injury to feelings during the course of employment, but not related to termination, then generally speaking, that award should be free of tax. If it relates to the termination of employment, then it is the same as an unfair dismissal award or an ex gratia payment on a settlement agreement, in that the first 30,000 would be tax-free and the remainder would be taxed. But that, of course, takes into account any other payments that form part of that £30,000. Injury to feelings are sometimes where there are discussions at the settlement stage and where there is a need for any settlement agreement to be very precise about what the compensation is for. Because if it's a claim for unfair dismissal and discrimination and you just agree to pay someone £60,000, it might be the second £30,000 of that is taxable. However, if the second £30,000 is clearly, and you're not being dishonest here, but is clearly related to injury to feelings from events arising before termination, then there are other arguments that can be made about it. So that does become important in the settlement context. Finally, protective awards. There are two types of protective award that can be made in the Employment Tribunal. One is for a failure to inform and consult collectively about a redundancy, and the other is failures to inform and consult about a TUPE transfer. On redundancy, the current guidance from the Revenue is it depends on when the protective award payment is made, rather bizarrely. If it's made in the same year, same tax year as the failure, then it will be taxed in the normal way, and it, rather bizarrely, in my view, constitutes a benefit of employment. If it's paid in a later tax year, then the usual £30,000 rule applies, so it's taxed under that section. In relation to protective awards on TUPE, I've put a question mark there. Interestingly, when I sent these slides through to Tom for checking and submission before this seminar, he checked with me whether that was a typo. It's not a typo, and the answer is I don't know the answer. There is conflicting guidance on it. There doesn't seem to be any firm view, any firm guidance from HMRC or anyone as to what the correct tax treatment of a protective award in relation to a TUPE transfer is. And so there you go. We're going to conclude the seminar with a question mark. We've got a bit of time to pick up some questions. So just picking up some questions. We've had one, I think, Amanda, you covered this, but just to clarify, we talked about the yearly cap on unfair dismissal and the statutory cap. But in what circumstances would that not apply to an unfair dismissal claim? It's a question we've been asked.
Yeah. So it won't apply for certain automatic unfair dismissal claims. One is in relation to whistleblowing. So if someone was a whistleblower, they were dismissed because of the concerns that they raised and brought an unfair dismissal claim. In those circumstances, there'd be no statutory cap on the compensatory award. And the other is if it's in relation to a health and safety reason. To use an example, recent-ish example that we probably rather forget about, but during COVID, some people said that they felt it was, say, dangerous from a health and safety perspective to carry on working, say, in the conditions that they were working in. If they, say, refused to work and they were dismissed under those circumstances, if the Employment Tribunal had found that it was a genuine health and safety issue, then that type of unfair dismissal claim awards would have been uncapped.
Thanks, Amanda. I think one for you, Nicola, covering reinstatement and re-engagement. We talked on reinstatement about preservation of continuity of employment, etc. But someone's just asked for clarification. For re-engagement, is their employee's continuity of employment also preserved?
Yes, yeah, it is preserved in either circumstance, and in either circumstance there's a potential claim for back pay. And just linking that with what Amanda was just saying as well about when the cap doesn't apply, of course that cap wouldn't apply to any claim for back pay in that interim period as well. So for high earners where they're going to end up busting the cap, if they were to claim unfair dismissal, again, it's another example where they may prefer to claim reinstatement or re-engagement because they can get their full back pay.
Brilliant. Thanks, Nicola. Another question here. Is there any way for an employee to get temporary reinstatement during the process? Because it might often be too late at the end of the process. And I think the answer to that is, in very limited circumstances, there is this concept called interim relief. I didn't cover it on the slide because it's even more complicated than tax treatment. But the general principle is, in certain circumstances, so if an employee claims unfair dismissal because they're a whistleblower, or for the sort of circumstances that Amanda outlined, or it's relating to health and safety activities, or it's related to trade union membership, an employee can apply for what they call interim relief, effectively to be reinstated pending the outcome of the tribunal process. The principle there being, well, those are circumstances where otherwise an employer could too easily just get rid of a troublesome trade union representative and worry about the money later or the reinstatement later, or could easily get rid of a whistleblower and again worry about the compensation or the reinstatement later. And there ought to be additional protections for those employees. But a claim for interim relief has to be made within 7 days of the date of the dismissal. So you'll be aware that in the normal course of events, you have 3 months from the date of dismissal to go to ACAS, and then a subsequent month in order to bring a tribunal claim. Has to be brought within 7 days. So we don't see many applications for interim relief. The threshold for an employee is that they have to show that it is likely that they will be found to have been dismissed because of their whistleblowing or their trade union activities, i.e. it is likely that they will succeed with their claim. And generally, at interim relief hearings, the tribunal says, well, this is just intended as a temporary measure. We're not going to have a full hearing. We're not going to have oral evidence. So you have to show us pretty convincing evidence that you're going to win your claim in order for us to go to the employer and say they need to preserve your contract of employment and continue paying your salary. But it might apply, and it has applied in cases where the employee can go to the tribunal and there is a clear email saying, we must get rid of this troublesome so-and-so. I don't care if they're a whistleblower. I don't care if they're a trade union rep. Just get rid of them. We'll worry about it later. Then the employee in those circumstances could claim interim relief, would be likely to be granted interim relief, and that has the consequence that effectively, up until the date of the tribunal claim, they still get paid their salary and benefits in the normal way. Another couple of questions. We've just got a minute or two to finish this. We've had one: when would it be reasonable to not appeal against a decision? Yes, so there are circumstances in which an individual might be found to have reasonably not appealed. An example would be if the appeal was going to go to the same person as the dismissing officer, which quite often happens in small employers. So if you're working for a small employer and there's just the owner manager and they dismiss you and the appeal is back to that owner manager, yes, to comply with the ACAS code of practice, you should appeal. I think the employer is unlikely to be able to reduce your reward on the basis that you didn't, because you would argue, well, it would have been the same outcome. Final question that we've had: can compensation be reduced for constructive dismissal claims where a grievance has not been raised? Again, yes, in theory, you can say there was a failure to follow the ACAS code of practice and therefore compensation should be reduced. Employee bringing a constructive dismissal claim isn't obliged to raise a grievance, so again, it wouldn't necessarily determine the liability issue, but in determining just and equitable compensation and taking into account that, then a tribunal could consider, well, yeah, actually, you shouldn't get as much as you would otherwise, because had you raised a grievance, things might have worked out differently. So it's a fair point, and it's an argument that we do raise in response to constructive dismissal claims. There were no other questions on the Q&A function, so hopefully we've answered everything, every question everyone had. Thank you very much for your time attending. I think we're finishing with about 15 seconds to spare, so that's a good effort. Enjoy the rest of your afternoon, everyone. Thank you.